Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon and welcome to the North Carolina Court of Appeals. I know that some of you folks have come a long way and we always appreciate having company from the western part of the state. We have one case on the docket for oral argument this afternoon, Great Smoky Mountains Railroad LLC versus MACH 2 Investments LLC et al. I'm not going to read the entire caption. Your panel this afternoon, to my right is Judge Jeffrey Carpenter, to my left is Judge Julie Flood. My name is John Tyson. Our clerk in the court is Mr. Roderick Farland, and our marshal is Mr. Tom Salou. So, are there any preliminary matters to come before the court? Hearing none, we'll hear from the appellant. Good afternoon.
Good afternoon. May it please the court. My name is Bo Carpenter. I'm an attorney with Allen Stoll Kilbourne and a member of the Buncombe County Bar. It's an honor to be here today. It's a pleasure to represent the Great Smoky Mountains Railroad in this matter. I would like to reserve 5 minutes for rebuttal today, please. This is an action by the railroad to enjoin the defendant's unsafe and unauthorized use of the railroad tracks. The trial court dismissed this matter on 12b-6, effectively ruling that the railroad did not have the ability to bring this action to enforce the rights of the railroad. Before getting too far into the nuts and bolts, I did want to provide a little bit of context with respect to railroads. Namely, state law is that railroads in North Carolina have, quote, the duty, even in the absence of a statute, to keep its crossings safe. That's the Norfolk Southern Railway versus Smith case from 2005. They also have a statutory duty under North Carolina General Statutes 136-192 to keep its crossings safe. And railroads, as a result, will commonly litigate their crossings, unsafe crossings in particular. The most recent case is the Shorts versus Caldwell County Railroad case from 2009. And in that case, the railroad actually closed down a long-existing crossing. And the court held there, quote, it was within the railroad's authority to determine that the crossing interfered with the use of the railroad and subsequently closed the crossing. This matter is a relatively standard case by the railroad to enjoin some dangerous use of the tracks. And specifically, paragraph 44 of the amended complaint alleges that the defendants, quote, posed a safety risk to the operation of the railroad that must cease or significantly abate to assure the safety of the public and passengers and employees of the railroad. That's why the railroad brought this action in the first place.
Can you, I know that the factual record here is in the briefs and laid out well. The question I had, going back to give a little context to the history, is sure. During the construction of the TVA dam, it would have severed the existing rail service between North Carolina and Tennessee, I understand. And as a result of that taking, there was a separate taking to reroute the railroad to continue service. Is that correct?
I'm not sure about the first aspect of that. I believe the West North Carolina Railroad, when it was formed back in, I think, 1865, maybe 69, went from Asheville to Murphy. I believe it terminated there. Okay. Now, if tracks continued after Murphy, I'm not aware of it. But certainly, that's where we trace our title to, was the original charter from the state back then. And so that was what was rerouted when the TVA came in and flooded the Fontana Valley.
And the interest that was acquired, was it a fee or was it an easement?
Fee.
It was fee ownership.
Correct. And as a matter of fact, the railroad's title from just west of Bryson City at least when it reroutes approximately at the location of Nanny Hill Outdoor Center, that's all fee simple property. So all the condemned property of the TVA was condemned in fee simple. It's not an easement right.
And your client continues to actively use it today?
That's correct. They actively use it. They do not use the branch from essentially somewhat west of NOC to Andrews. They don't use that section of the track for passenger use, although they still inspect it and have an obligation to ensure it's safe use. But it's an active railroad track from Silva or Dillsboro all the way to the Nanny Hill Outdoor Center. And so it's very active. They run trains every day, multiple trains on the weekend. They transport hundreds of thousands of passengers every year.
Is it also used for freight traffic?
Not currently, but we have an agreement with the connecting railroad that allows for freight. And so they do have the ability to run freight to connect to the state transportation system. But last I checked, which has been several years, they don't currently run freight on the lines, but they can if they
Would that be with CSX or another carrier?
No, their interchange agreement is with a railroad called WACO, or Blue Ridge Railroad. That railroad runs from Asheville to Silva, where it intersects with the Great Smoky Mountains Railroad, approximately between Silva and Dillsboro.
Your client's primarily transporting tourists and visitors?
Yes, Your Honor.
So it's kind of a scenic type trip?
Very much so, and they run special events. One of the most popular ones is the Polar Express. That's done every Christmas time, and they're packed there with many passengers who use the rail. And yeah, it's a passenger rail if you're looking for a technical classification, but they run it for tourist reasons.
So tell me about the involvement of the state and how that became involved.
Sure. After the TVA took title to the tracks, they conveyed it to the Southern Railway Company, which is now known as Norfolk Southern. The state of North Carolina purchased the property from the Southern Railway Company. I believe it was a purchase. I want to say in '86. The record will say for sure. After that happened, the railroad was formed, as a matter of fact. The Great Smoky Mountains Railway, as it was then known, was formed, and they operated excursion rail on the pursuant to a lease. In fact, I rode on that rail when I was in 5th grade when it first formed, and so the DOT leased it to them, and then of course you had the deed from 1996 where the DOT conveyed the property to the Great Smoky Mountains Railroad pursuant to a quitclaim deed, which turns 30 years old this year.
And I'm correct that adverse possession does not typically run against either a public entity or utility or rail. Was that correct?
Yeah, North Carolina General Statute -144 says you cannot adverse possess a right against a railroad. Not only that, you can't assert an implied easement right to use railroad property by virtue of possession of that property.
So the normal process to transfer state property is through agreement approved by the Council of State, signed by the governor, tested by the Secretary of State, correct?
Correct. Yeah, that's a typical way the state disposes of property, except for DOT property. DOT property has a process where they go through the Board of Transportation instead of the Council of State for approval. That's a different oversight department than the Council of State and the governor for the transfer of DOT controlled property.
Is the deed still signed by the governor and the Secretary of State from the DOT or not?
I don't believe so. I believe that's, I have to look. I'm not sure who signs the Board of Transportation deeds, whether that's the Secretary or somebody else.
So basically, from that title of 1996, that quitclaim deed that's where you're claiming title under?
Yes, sir. Yes, sir. And that's been, and the railroad has operated under that title since then, again for 30 years, and brought many enforcement actions. successfully done so. And it's their job as a railroad, both federally and state, to ensure the safe use of it. And if they don't, they can be sued. There's plenty of cases, mostly older cases, where the railroad's been sued, personal injury running out of their obligation to ensure the safe use of the tracks.
So if you have a existing usage by an adjoining property owner through a crossover that has been there a long period of time and has been used by them to access their property, what's the railroad's position on how do you reconcile or how do you recognize or accommodate that?
Well, it all comes down to safety, right? Generally speaking, if the property or the crossing is not causing an issue, then the railroad's not going to say anything about it. Obviously with DOT crossings, those are different. We're talking more about private crossings. And historically, this crossing was just a farm crossing to reach a pasture, to reach a farm.
It connected with Highway 19, is that correct?
Correct, public road. And that's the only, they allege it's the only access to the road. I don't think I don't think that grounds for easement by necessity, but certainly the position is the only access. And that's the only access they're using currently. And so what was the concern here is they came in and they just, they put gravel over it, they did all this work on the crossing, and then you had churchgoers, property owners going back and forth over the crossing, and we sent them a letter, we warned them, this is in the complaint, that hey, this is not authorized, this is dangerous. And essentially they thumbed their nose at the railroad and said we're going to do it anyway.
Was the crossing there when you took title?
Yes, but not in its current state. As a matter of fact, the railroad has an inventory of crossings. The Federal Railroad Administration requires them to keep it. So that was
including a private crossing,
including a pedestrian crossing. It includes every single crossing of the tracks, including includes everything. It includes a lot. And so. So
how do you determine whether or not there's going to be protected crossing with gates and warnings or not?
I don't know the specific criteria for that. I believe it's statutory. I could be wrong about that. I do know under.
Is it based on usage? Probably.
Based on usage, but the case law, again, I'll point you to the Norfolk Southern versus Smith case, is very clear that the railroad has discretion to use its property for safety reasons. And the court's very clear there that the courts aren't to question that authority. As long as they can point to some kind of legitimate railroad purpose for the use, then they're allowed to do so. And safety, of course, is the quintessential railroad purpose under case law. So
if you have an easement across an owner's property that divides one side of his property is on one side of the track is on the other, even if you acquired ownership, can you prohibit that property owner from crossing the tracks?
Can the railroad prevent the property owner? Yes, they absolutely can.
Is that also true if you have nothing more than an easement?
Yes, yes. The way that works is both the fee simple and easement rights are considered the railroad corridor or the railroad right-of-way. And so there's a case, I forget the name of it, I think it's from 1953, that says essentially a railroad right-of-way consists of both fee simple and easement rights. And so the law doesn't distinguish between fee simple and easement with respect to right-of-way rights, for railroads at least.
Okay, so you mentioned that you provided written notice to them that to discontinue the use of the crossing. Is that correct?
Well, even before they did that, before they engaged in the construction activity, we were warning them not to do it. So yes, that's I don't think the timing is played in the complaint, but we certainly warned them of that ahead of time.
So how do we review the trial court's ruling? The burden is on you to show error and prejudice. Is that correct?
Yes, Your Honor.
So how do we review the trial court's ruling below?
Well, it comes to you on a 12b6, and so the decision of the trial court, of course, was that we didn't state a claim for which relief could be granted. And that's where the courts are reviewed de novo, I believe is the standard of review, and at least the legal issues.
So that's a matter of, court rule is a matter of law.
Correct. And so here, the defendants essentially argued that we didn't comply with the Chapter 146 Council and Governor approval process, and therefore the title is no good, and therefore the railroad cannot police its right of way. And we argued that they were, in response, we argued, and we argue today, that they were exempt from that approval process. The DOT is exempt from that approval process, particularly with respect to highway rights of way, borough pits, and other interests in estates and land.
Now, they're arguing that the title was not deeded to the DOT, the title was deeded to the state of North Carolina, correct?
That's their argument, yes, Your Honor.
And that, and you're countering that the allocation of state property among agencies of the state is a matter internal, correct?
Correct, Your Honor. On that point, we're actually saying a few different things. That is one of them, is that the Department of Administration, for example, can allocate state property without there being a deed. And so that's an example of where the gap in title between the state and the DOT is not fatal to the deed at all. And also, on that point, for purposes of a 12b6, the railroad has alleged that they have a deed. They attach the deed to the property as part of the complaint. And so that is enough to show, at least on the 12b6 stage, when the pleadings must be liberally construed and factual allegations taken as fact, that's enough to get over the 12b6 standard with respect to that deed. And also, a deed statutory, is presumed to be valid. Now, certainly, the defendants have the right to attack that, but that's an answer and counterclaim. That's not a 12b6 attack. And they've alleged in their answer and counterclaim that they have an implied right to use the tracks. And they cited that. They cited their answer and counterclaim in their briefs as supporting their argument for standing. I think they have a standing issue here. Somebody is only afforded standing when they have a legal right. Here, the defendants, based on the pleadings, based on the complaint, do not have a legal right to use the tracks. They just don't. It's not pled. It's not part of the public record.
They don't want to use the tracks. They want to use the dirt under the tracks to get from one portion of the property to the other. They don't. I don't think they're going into the freight hauling business or the passenger hauling business. They just want to access the property on the other side.
Well, respectfully, they are using the tracks. They are not traversing the tracks, but they are going over the railroad tracks. And those are railroad tracks that the railroad has an obligation to maintain. They're not the ones who are putting in railroad ties. They're not the ones putting in the rail, but they're going over that rail in order to get to their property. So I would argue that they are using the railroad tracks, just not in the same way that the railroad is.
Counterclaims in this action are still pending.
Correct.
Do you agree it's interlocutory?
I do. The title.
Tell me about your substantial right as in regards to an easement.
Title claims are a decision, trial court decision affecting title constitutes a substantial right that allows for the interlocutory appeal.
What's your authority for that?
My authority is quoted in my brief. I don't have it with me, but it is in my brief for that authority, and I believe it's something that the defendants have conceded.
As to an easement?
With respect to title, I think easements are also part of title, just like fee simple property is. And here, when you're talking about railroad right-of-way, there's not a legal difference between the two with respect to the railroad right-of-way rights. And so I don't have any authority with respect to an easement. I'm happy to research that and provide that to you after today, if that's helpful.
But you're claiming fee ownership, correct?
Yeah, this is fee ownership. That's correct.
So there's another argument concerning the failure to join the state as a necessary party.
Yes, Your Honor.
I don't want to interrupt your argument. I just want to make sure that we cover all the issues.
Yes, I think that's a major issue here, because the state, if the trial court is correct, we don't have title, and the state has title, or the DOT has title. And so the decision effectively caused title to vest into the state. and they weren't even at the hearing. And not only that, the issues in this case concern the internal machinations, let's say, of the executive branch and how it allocates property and how it functions and how it approves things. And I think that's something the state has material interest as well in being a part of this case over. And finally, you have the material interest in the economic impact of the railroad in a court's decision. The rail industry is a $20 billion industry for the state. And the court's decision here would have reverberations throughout the rail industry. If an adjoining property owner is allowed to collaterally attack the conveyance between two parties, then I think that opens up a challenge to other railroads. And all it takes is one property owner to interrupt one sliver of railroad property for the entire railroad industry to shut down in the state. And so I think that's another reason why the state needs to be here, is they have a large financial interest in this matter, and that gets to some of the public policy considerations here. Public policy is not something that we brought up, it's something defendants brought up, and they cited the public policy of North Carolina enunciated in 136-44.35 that railroad corridors are, quote, vital to the continued growth and prosperity of the state, and they serve a public purpose. Well, railroads are vital to the state. That's the public policy. So a decision here that a adjoining property owner can collaterally attack a title that's 30 years old past the adverse possession period of time when the state only has 21 statute of limitations on enforcing, on voiding a title, that opens the door from any adjoining property owner to challenge any deed from the state to a railroad, even if it's more than 30 years old, even if it's ancient. And so from a matter of public policy and repercussions of court decision, that certainly favors the enforcement of this title and enforcement of a railroad's right to manage this right-of-way, to make sure that the rail is safe. We're talking about safety is of paramount importance of the state, to make sure that its railroads are operated safely. And a matter of fact, the DOT has an obligation statutorily to assure that the railroads are safely run. And of course, you have the federal State Transportation Board and FRA regulations that control safety that the railroad's bound by.
In terms of I understand the deed actually covers 66 miles, is that correct?
I believe so, yes.
And so, had there been other challenges prior to this one to your client's ownership other than this?
One, and Mr. Matney, I'm so thankful to talk about this. He represented these same parties back in, I want to say 1999, 98, alleging the same thing.
The same crossing or yet a different crossing?
Same crossing, same party, same argument. And I was not involved at that point. Of course, that was a long time ago. But I understand the railroad dismissed that case without prejudice. And so it's not been, other than that, nobody's ever raised an issue. I've represented the railroad probably in at least half a dozen actions, and no property owner has ever raised an issue. In fact, we always settle these by entering a license agreement that allows the use, but just under our purview to make sure safety is concerned. And we typically charge a license fee every year, but it's pretty de minimis for just an individual property owner. But we want to make sure that we're identified and they're insured, and that there's an understanding that we have the right to come in and police the right-of-way. If they want to work on the right-of-way, that's fine, but we need to provide oversight. We need to provide employees. We need to provide a trackman to be there to look it over. And honestly, that's what we saw with these parties, was some kind of agreement for the use. And that didn't happen. They just proceeded with the construction.
So you saw, and this is in the record or not?
This is not in the record, no.
Okay.
It's in the record that we warned them ahead of time of the issue. I don't recall if we sought an agreement or not. But I believe that's on page 28 of the record. But the record is what it is there.
So what claims, going back to Judge Carpenter's point, what claims remain pending?
They have filed a counterclaim for an implied easement. I believe it's an implied easement by necessity, but I could be wrong about that. Certainly they've alleged an implied easement varies across the tracks, and so that claim is still pending before the trial court, and nothing further has been done on this matter since the dismissal.
Were you trial counsel, or were you here for the?
I was trial counsel, yes.
You were trial counsel. So that's the only claim. There's not a damages claim or anything else pending with that?
It's a pure claim to enjoin their use of the right-of-way. So yes, no damages.
I think you've reserved 5 minutes. You got about a half a minute left. I don't want.
If I could reserve that half a minute extra for rebuttal, that would be great.
Okay, one moment. Okay, we'll reserve that extra time
Thank you.
for any additional rebuttal you wish to offer, Ms. Carpenter. Thank you.
Your Honor.
Here for the appellate, and the court did receive prior notice from the appellee that you wish to divide your time.
That's right, Your Honor.
And we understand that you are going to take 5 minutes and co-counsel will get up to 25 minutes.
Other way around.
You're going to take 25 and up to 25, and whatever balance would remain for co-counsel.
That's correct.
Okay, good afternoon.
Well, thank you, Your Honor, and may it please the court. My name is Jonathan Dunlap. I'm here with David Matney and Zipporah Edwards. One other attorney involved in this, David Sawyer, wasn't able to be here today due to medical reasons, but we represent the defendants in this case, and David's going to be the one to take our remaining 5 minutes at the end. First, I just want to make the point that we're not here today to put the Great Smoky Mountain Railroads out of business. They operated on this railroad corridor under a lease agreement with the state from 1998 to 2013. If they lose this case, then they're holdover tenants of the state. They can be there as long as they want until the state decides to get rid of them. Our clients are residents and citizens of the state of North Carolina. For many of these people, this actually is the only road. This is the only access to their private residences. It's the only access to the church. There's one tract of property where they may have other access, but they're not sure about that. But for most people, this is it.
Access to Highway 19.
That's right.
You're referring to that.
The only way to get to their property, out of their property and onto the property. They and their predecessors have been using this easement for decades. It's been reserved in the chain of title back to the TVA, at least back to the TVA condemnation. So all the way in the record on appeal, it's been reserved every step of the way. So plaintiff's claim is right.
Your chain of title runs directly to the original grantors who their property was taken by the TVA for the rerouting of the railroad. Is that correct?
That's right. The DeHart property, I think all of us trace our chain of title back to that DeHart property, which was the property that was severed by the TVA. So,
well, let me, as a preliminary matter, are you arguing that the appeal is interlocutory and maybe we shouldn't even hear it? Is that part of your argument, or do you think we need to go ahead and address it?
We have not contested the interlocutory nature of the appeal. I mean, as the court knows, that's a subject matter jurisdiction issue. The court's going to do what it's going to do on it with or without our argument, but we have not contested that.
Okay. How should we review what the trial court did?
Well, the trial court decided this under 12b-6, so it would be de novo, but this really is a standing issue as well. And as the court knows, you can entertain standing. There is no preservation of standing issues. It's a subject matter jurisdiction issue. You can entertain that whenever you want. And this is a standing issue. If they don't own that if they don't own the fee simple title to that railroad corridor, they don't have standing to bring this lawsuit in the first place.
If they were a holdover tenant, as you described earlier, would that not give them standing to try to assert claims to the?
So that, on that point, I would disagree. I'm not sure as a holdover tenant they would have the right to contest our claim of easement. But at a minimum, that claim would look a lot different than it does than the one they're making today, where they claim to be the owner of the fee simple rights.
If the property was acquired by condemnation by the state, there could be no reservation of an easement, correct?
Wait a minute, no, I disagree with that. When the TVA condemned it, these easements were reserved. And Mr. Matney can speak more to that, but you can look at the old plats and you'll see that they reserved these easements specifically as part of that language. They sort of made a different condemnation of those easements so they could work on the railroad, so they could build the crossings. So if they weren't easements prior to the condemnation, they would have just condemned the whole thing. There wouldn't have been this little carve out about, we're going to take this as a construction easement essentially to work on the crossing. These appear on the plats and maps that they have, you know, that we presented to the court in the record that are referenced all throughout the chain of title. So those easements were carved out at the time of the TVA condemnation. They reserved those easements. And so when you fast forward to when the state takes it, those easements are also reserved in what the railroad company deeded to the state of North Carolina.
Well, generally when a condemnation occurs, the condemning party or entity takes free of the easements. They have to pay for them, but they take property free.
I understand that. Evidently, the federal government decided that they were going to carve out those easements and that they would reserve those easements. I don't think there's anything preventing a condemnor from doing that. But in 1943, the TVA, that's how they structured it.
And the location of the crossing has been unchanged?
That's right, yes.
There's a concept in law called overburdening the easement. Are you familiar with that?
I am.
We had a case out of the mountains where there was a crossing over a creek just to get to one house on the other side, and all of a sudden the property was sold and an apartment building started showing up, and they wanted to widen it and put a permanent bridge in, blah, 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 blah. You want to, or I understand you've done work on the easement.
That's right.
The crossing, I'm going to be more specific, and that was done without the oversight of the railroad. Was that correct?
That was done without the oversight of the Great Smoky Mountain Railroad Company. Now, I want to be clear, and this is something that we dispute that they are a railroad company. A railroad company is a defined term under the North Carolina statutes. A railroad company is regulated by the North Carolina Utilities Commission. A railroad company has the state's power to condemn. Now, they can only condemn a lease interest, but they can condemn. If this were Norfolk Southern, we wouldn't be here disputing ownership. They would have just condemned it, and they would have paid us for the condemnation rights. So
They claim to own it in fee already.
I'm sorry, yeah, I know they claim to own it in fee, and we're disputing that, but I just want to get back to this point. That this is not a railroad company. This is an amusement ride that this company runs in a North Carolina railroad corridor.
Are they subject to the same safety or regulations as a railroad?
It's anytime you run something public, a place of public accommodation like that, I would say you do own the safety issues in it. Now, they may not look exactly the same as a railroad corporation's safety requirements. I mean, ultimately, those are going to be established by federal regulation. And, you know, but I want to return to your point about overburdening the easement.
Let me ask you,
Okay, go ahead.
is the plaintiff subject to federal regulation?
As far as we know, I mean, no more so than, you know, they're subject to pay federal income tax and those things like that, but they aren't subject to the same federal regulations that Norfolk Southern is. So there may be some, it is a federally regulated crossing, for example. So there may be some duties on the part of the, you know, the lessee to comply with regulations about that crossing. If you're going to run a train through it, you got to do that. But I want to make that distinction that this is not, ultimately their argument is that the DOT had the power to do this. They had the power to write this lease and transfer this property, this state property, in this sort of, you know, unenunciated, uncodified general power of the NCDOT to manage the state transportation system. This railroad does not involve state transportation. No one commutes to work on this. It doesn't carry coal from West Virginia. It's an amusement ride for tourists to go on. So to say they're transferring this deed out of some sort of inherent authority to manage the, the state transportation, that's not what this is.
As an amusement ride, could passengers board at, say, I think, the Nantahala Outdoor Center? And there was mention of Silva and Dillsboro. Is there a place for those passengers to disembark in Dillsboro, so be transported from one location to another and be done with the train ride?
So I don't know the answer to that, but I can tell you if they do disembark, I don't know how they'd get back.
But you heard counsel's representation to the court that there are agreements in place that would allow freight haulers. As far as their arguments, our understanding is this is still a protected, regulated rail corridor. And there are other users other than just them that have access and the right to use it, and it must be maintained in accordance with the federal standards. That's what I understood Mr. Carpenter's argument to be.
So we couldn't agree more. This is a railroad corridor. This is a state railroad corridor, and it needs to be preserved under the statutes governing the preservation of state railroad corridors. That's Chapter 136, Article 2D is called Railroad Revitalization. Under that chapter, under that article, the NCDOT is charged with the preservation of state railroad corridors. There's no authority for them to transfer or dispose of railroad corridors in fee simple. The entire point of that statute is if you have railroad corridors these days, these railroad corridors, remember, these were built back when land was cheap and there wasn't a lot of commerce. And now it's the opposite around those railroad corridors. If you lose them, you will never get them back. And so the DOT has the authority to lease these things out. It can even lease them out for recreational purposes. But there's no authority anywhere for them to sell it in fee simple.
So if I want to ask two questions about the state.
Sure.
The need for them being a part of litigation being necessary. And two, if the deed fails, aren't you back dealing with the state, and could not the state regulate the crossing as well?
So let me take the second one first. Yes, we would be back dealing with the state, and if they cut off our client's access, we would bring an action for inverse condemnation.
Okay, what would be the basis of the claim if other than usage?
That we have an easement, that they're condemning our easement rights.
That you're contending was reserved in the original transfer to the TVA.
That's right, and we have other theories. We have other claims, but that's the primary, and I think the strongest one is you have easement by plat. But we also have easement by necessity and various other theories.
And that claim still remains below.
That remains below, but the lower court's decision has essentially mooted those claims. So unless until this court overturns the lower court or reverses the lower court, then those claims remain moot. Now, this is another thing I want to defer to Mr. Matney, but his clients have claims. They do actually have claims for damages. They have slander to title claims. In those claims, they have an independent jurisdictional basis. And so if this court says, okay, defendants, you win, it will moot all of our easement claims, but those claims will remain. And it will be, those will still be active in the lower court because they have an independent jurisdictional basis.
The 12B6, the granting of a 12B6 is necessarily, would you agree that it's highly deferential to the non-moving party?
I would agree.
And it's a very early means of terminating a lawsuit.
I agree.
And it's not even here where an answer, it's not even a 12C, it's basically based on the pleadings alone.
That's right.
Basically just on the plaintiff's complaint alone.
It's the complaint plus the attachments, and
right.
The attachments show they say we own chain of title because the DOT transferred North Carolina Railroad corridor to us. And that's sufficient. We didn't have to file an answer. The court doesn't need to get to the answer. All it has to do is look at that deed and try to find any authority for the North Carolina Department of Transportation to transfer railroad corridor back in 1996. And it's not there. And even if it were there, we get back to our argument that the DOT has to have it's a transfer of state property, and so it has to meet these criteria of Chapter 146, where it is approved by the governor, the council of state, and because it's worth over $25,000, the Joint Legislative Commission on Governmental Operations, and these things have to appear on the face of the title. So the title is void because it's ultra vires. The title is void because they never went through that process. They don't even allege that they did. And the title is void because it is defective on its face. And we've given you case law to say if a title is defective on its face, it's not voidable, it is void.
There's been changes in the statute that specifically allows DOT to transfer what refers to as remnants. Is that correct?
I think it's residue is what it's called.
Remnants or residue? Okay.
And so and that's true. And I think that statute just goes to show, it just goes to prove what we're saying. That statute, it was passed in 2017, and it says that the DOT for these residue properties, it defines that it's basically property that it condemns. It doesn't have much economic value, but it just condemns it anyway because, you know, it's worthless to the owner. What happens to that if the DOT doesn't need it? And it says that if it's worth under $10,000, the DOT does not have to go through the governor or council of state. If it's worth more than that, they do. Another point to make there is, even if it's under $10,000, they still have to get approval from the Board of Transportation. Now, under plaintiff's theory, at least as I understand it on the briefs, plaintiff's theory, they can just transfer this railroad corridor without anyone's approval because it's part of some general power that they have. That doesn't make sense. Why would the legislature want the Board of Transportation, at least one other party, to approve transfers that are worth less than $10,000 if they can just transfer it? You know, if the state of their power was they could just transfer it on their own volition.
I was looking at the record. I was trying to find out, and I know that the DOT is not a party. I understand. But I was trying to go back to try to find out the basis of the transfer. Do you know anything about that? Maybe co-counsel will address that. But
the basis of which transfer?
Back in the 90s, I know that they were a tenant. They had a license agreement
right.
that ultimately ripened into a deed from the state. Was there a meeting of the DOT or board meeting, or what was your understanding of the basis of their rights being no longer being a license and being a deeded interest?
So you're talking about the transfer in 1996, this deed that we're talking about,
right.
That transfer, okay. So,
but there was,
frankly, Your Honor,
they had a relationship prior to that.
Right. Frankly, Your Honor, if you look at the way it's signed, we think that, that they had the lease agreement, and the lease agreement has certain requirements, and it's signed by, I think, the Board of Transportation Secretary. It's signed by the DOT Secretary, and it has the stamp of the DOT. We think that's what they would have to do to lease it. And we think that that was a mistake that occurred, that one day somebody said, why don't you just sell it to us? They said, we'll do it. And they skipped the entire administrative process that they were supposed to go through, and they just did the same thing that they did as though they were leasing it. And these statutes exist to prevent exactly that from happening.
Can some apparatus of the state, whatever that apparatus may be, whether it's the Board of West Council of State, Board of Transportation, Department of Transportation, whoever that may be, can't that state apparatus just backfill and feed the estoppel under your theory? And if the answer is yes, doesn't that make the case for this being a voidable deed and not a void deed?
Okay, so first of all, the statute that you're referring to, well, the statute that they refer to under their ratification argument, I think that can be resolved with a plain language reading. Statute 146-66 says any sale, lease, rental, or other disposition of state lands, or of any interest or right therein made or entered into contrary to the provisions of this chapter, chapter 146, shall be voidable in the discretion of the governor and council of state. So, number one, it shall be voidable in the discretion of the governor and council of state. That means they have to do something first. It doesn't exist in a voidable state. The governor and council of state have to take action to make it voidable. So it would not, even under their theories that voidable properties or voidable deeds can transfer property, it is not voidable until and unless the governor and council of state say it is. That's the plain language reading.
Isn't that another argument for the state being involved in litigation?
So Your Honor, the state doesn't need to be involved in this litigation, and that's because the only rights at issue, this is plaintiff claiming that they own this property in fee simple, and we're saying you don't because your deed is void. I don't think this, if we're right, then what that means is this title never left the state in the first place.
If the deed is void, there's no way to make it voidable. It's just a nullity.
If it's void, there's no way to make it voidable. So, and let me sort of walk you through my understanding of how this works. So first of all, the statute I just read you, insofar it says, as it says, entered into contrary to the provisions of this chapter, all that excuses are problems, all that could possibly excuse are problems in the 146 procedure. So some sort of procedural thing that didn't occur. This says the governor and council of state can go back and say, well, we're going to decide that's voidable. It does not solve the problem of an ultra vires transfer.
Do you challenge any of the state's title?
The state's what?
The transfer from TVA to the state, are you challenging any of that?
So we don't challenge that here today. I mean, I don't want to commit my clients to that going forward, but that's not something that we're doing.
So you're not, throughout all of this, you never challenged the state's title?
We have not, no. The only case, and I want to point this out too, the only case on this 146-66 is that Stewart v. Graham case that we cited. In that case, there was an oral lease where, Department of Administration tried to lease somebody some property, and the court said that's a void lease because it doesn't comply with the statutes. Now, they cite this statute, they cite that language about voidable in the discretion, but that didn't make a difference to the court's decision. They didn't say, well, because it says that, it's voidable, therefore voidable deeds can transfer property, so we got to wait for the governor and council of state to weigh in before we decide this is void. No, the court just said, no, this is void. It doesn't transfer anything.
Are you familiar with the concept of a just tertiary defense?
I'm afraid not, but maybe I misunderstood you.
Justerti.
No, I'm afraid
Just
not.
tertiary. Just tertiary is trying to assert a right that rightfully belongs to a third party.
Okay.
So basically, you're trying to say you don't have a right because the right is in the state of North Carolina.
That's exactly what we're saying. If it's in anybody, it's in the state of North Carolina.
Well, you may want to look and see if you can even raise that by trying to prove your right through the absence of something that's in a third party. And that would almost speak to the absolute necessity of the state being a party.
So, Your Honor, if you dismiss this case and you say they don't own what they say they own, that means there's no subject matter jurisdiction. That means it's as though
But we would have to find it belongs to someone else other than them.
I don't think that's true. I think you can get around on this without making that decision. I think the way you get around on it is you say the deed is void. It does not belong to them the way they say it belongs to them. And then you leave that question open. I don't think you have to make the decision that it belongs to the state or it belongs to, well, they didn't transfer it.
How do we do this? It was dismissed at 12B6 down below. How do we get to the point where we're analyzing the undercarriage of what what the court may have looked at down below when it's just I'm dismissing it pursuant to 12B6? That's what we got.
Well, so first of all, standing is always an issue, and you're not bound by the pleadings when it comes to standing. All of this is fair game. Second of all, our theory, most of these arguments are purely legal ones. You really don't have to go outside of the deed itself. We're saying it's an ultra vires transfer. It's void on its face.
Who interprets the deed and what it says? Do we do that in the Court of Appeals, or is that something that happens at the trial court after arguments of the parties?
Well, it happens at both stages. I mean, the court looks at the deed, the lower court looked at the deed, and it said, you're right. We agree with you. We don't think they own this.
No, the court said I'm dismissing it pursuant to 12B6.
That's true. That's true. The arguments that were...
It was not adjudication on the merits.
I will say 12B6 is a little more narrow in that the court can only listen to what the arguments that were made. And those were essentially the arguments that were made. And so that's why I say the court decided on that. And I know what the order's open-ended.
So has not been answered. There's been counterclaims asserted, right?
Right.
But no answer.
I think there have been answers. We filed answers, but...
So why wouldn't you have moved under 12C and let the entire pleadings be considered?
We didn't need to. They had attached the deed to their complaint. That's all we needed. That, and we did raise this under 12B1 in the lower court. So,
did the court rule on that or not?
The court, that's not in the court's order.
On 12B1.
But that doesn't matter. With the court's permission, I'm going to allow my colleague to come and...
Thank you, sir.
Thank you.
Good afternoon.
Good afternoon.
Have you spent a lot of time in this title over the years?
Oh, Lord. This is one of those things that's been with you forever. I represented Bruce Green, Mr. Chris Green, one of the current father, when this plaintiff, actually it was the predecessor because they were a corporation, they've converted to an LLC, but I'm going to call it the plaintiff, sued for exactly the same thing. We own this, you can't cross. But what they claimed, their complaint just said, we own it. You're trespassing. That survives 12B6. Discovery, how do you think you own it? We own it, the deeds that are listed in their complaint this time. They saved us discovery this time. Last time, we had to get through admission, this is how you got it, this is how you got it, this is how you got it, that they put in their complaint. So we go up for summary judgment. Bryson City, I was there. The judge said, listen to their argument, said, can y'all come up here? I said, sure. We said, sure. And he said, looked at the plaintiff's counsel and said, do you really want me to rule that your client does not own this land? And they took a volunteer dismissal. Okay? Now, from our point of view, this right-of-way had been used since the 40s because the person condemned used it. Mr. Green used it. They've used it the whole time. His son, Mr. Chris Green's used it. And we had no reason to bring it up again. We've got a right-of-way till the plaintiff sues again, 23 years later. Now, plaintiff's counsel said, oh, we warned them. 2 years before we filed the lawsuit, I got sent a letter that's referenced in the complaint. You don't have this right. Well, it's a different counsel. So I sent him pleadings last time, the summary judgment, and said, and you took the dismissal. Show me any law that's different, and we'll look at it. But if you don't show me any law that's different and you file, we're probably going to sink sanctions. The next thing that I heard was 2 years later, the lawsuit was filed. Nothing went on for 2 years. Okay? But I was a little shocked when it happened. They didn't even call and say that. We think all these arguments that are raised in the brief today were never brought up before the lawsuit was filed. Don't know why they thought it. The 8,000-pound gorilla, the railroad.
Would you agree, and I understand your argument is they have no rights. Basically, if their deed is void,
Yes,
I understand counsel's argument that that's, but it's clear that they are at a minimum or a holdover tenant. Even
they're
if,
a holdover tenant. I agree with that.
okay, that's a property
But
right.
we were using the railroad before they were a tenant. They're leased what's there. We're there. They let us use this for 20-some years. They let prior tenants use it. Now, and.
So are you arguing that when the property was taken by TVA, there was a reservation?
Yes,
of
and let me
rights?
point to that, and if you, this is in the record, a map that shows where the taking is, and it shows the roadways crossing the, mine is blown up, so I don't know what page it's on.
I think it's
It's attached to deed, I think.
Okay. Anyway,
Three.
if you look at all those, not just our farm crossing, but all the rest of them, they're actually called farm grade crossings. The government condemned the strip, this strip. They also condemned the right to build a entrance outside of that strip. Now, why would you need that unless the road crossing was to continue? If they took the road, they don't need to spend money doing that grade. They don't need to get that land.
But you would agree that the map would reflect current conditions, and if there was a crossing there, that crossing would be noted on the survey without necessarily giving rights from that. Do you agree with that?
I agree with that, but the condemnation and order, and it's in their complaint, says a farm entrance, and if you look on the map, is to get you from US 19 to this. A railroad track is not on the existing grade. It's always up, you have a ballast line to get it up so it's out of water. So they got the right to start and grade back here to make it to the car or vehicle or whatever could go across over the track. Why?
Now, is this a single track?
Yes, sir.
So it's a single track on a 150-foot easement.
Yes, sir. 50 feet on one side and 100 feet on the other side. Oh, in answer to your question, the Western North Carolina Railroad was actually first chartered in 1854, but that one failed and they did it again later, and then it was taken over by the state, and then there's a whole lot of history there that have nothing to do with any of this. I've read a lot about railroads. Anyway, why would the state, excuse me, would the TVA take a right to grade up to this if there wasn't a right of way? One final thing is the issue of safety. This train moves at a fast walk or a slow jog. It's one thing to talk about that, and it's called safety. And my client slander of title, he was building houses in there. They filed this lawsuit. He can't sell a house. He can't refinance a house. And he's even really mad because his wife was going to get one of them that was going to end his divorce decree. He can't give it to her, so they're still fighting about that.
So let me, in terms of enlarging the use, if you got a quote farm use designation or farm crossing, and all of a sudden you start subdividing and developing, how do you respond to that? You far exceeded the original. If you have an easement for farm use, how can you translate that into subdivided property?
It says farm grade. It doesn't say farm use. Plus, wasn't there a light rail case in Charlotte where they went from one train a day to a train every half hour, and they said that's not an increase in use?
Well, I'm asking. That's the reason
I think it's not an increase in use because if we did use this roadway to access other properties, that's an overburden. Whatever we do on this property is not an overburden going back to the Charlotte light rail case, whose name I don't remember.
So you couldn't go to a remote property, use this to
You could not go to a remote
to
property.
an adjoining remote property, but you, as far as the entirety of the original track, you
Anything
feel
you
like
want.
you've got a right to use it.
Yes.
Understand? You're out of time, but I want to give you a
Ask me
moment to
questions
sum
before
up.
I had left.
Yeah, well, I'll give you a moment to sum up, but I wanted to see if there's any questions from the panel, and they said no. So I just want to understand, originally when the original suit was dismissed, did things just continue on the way they always
We
have?
kept using. I will add that another thing that caused out, Mr. Bruce Green, the father, was also cutting trees in the strip. So that got him madder, and that's why they filed the lawsuit then. But after that, Mr. Green just kept using it. He sells it to his son. His son keeps using the road. It's just been used. The only thing they dismissed the lawsuit, so that judge would not enter summary judgment against them, saying they did not.
So who maintains the crossing?
Okay. The roadway is maintained primarily outside of the track by the users. My understanding from my client is that the plaintiff has done work on the railroad and done that. And if
Well, I guess my question is, when you cross over railroads, you got two rails, you got a gap in the middle. Who, is someone, and you don't want to drive over that dip, so
I think the railroad, well, should be, I don't want to call, I agree, they're not a railroad company. They're a business limited liability company with the word railroad in it. Okay, railroad companies are chartered by the state legislature, and most of them, but not all, have power of condemnation. They were all set up long ago. You can set one up now, but true railroad companies are chartered, their charter is passed by the General Assembly. This started out as a business corporation under Chapter 55 of the General Statute. It converted to a limited liability company under Chapter 57C of the General Statute. It's not a railroad company. It is a business entertainment company with the word railroad in it. They use a railroad in there. Looks like, is Tweetsy a railroad? No, this is just a longer one than Tweetsy. Tweetsy goes up and down. There's actually a case about a lumber company where they put in rails for their trees, and this court, and I don't remember the name of the case, said, no, that's not a railroad. You're using your own purposes to take this. They're taking people from point A for sightseeing. They may have the right to take freight, but they're not doing that. All they've done for 40 years is move people around at a slow rate for sightseeing. So it is a limited liability company, formerly a corporation, with the name Railroad in it. They're not a railroad company. Railroad company and railroad, but the chapter on railroad company said railroad company. And if I've done a lot of work on railroads. I knew some of the history. I've never seen the one that wasn't chartered by the legislature. There's a few that don't have condemnation, and one of those, because they had the right to put up telegraph lines, so they didn't give them condemnation for that.
So what would you have the court to do?
Affirm.
Affirm the trial court's
Yes,
judgment?
sir. And that we would go back, and the easements aren't, until somebody else sues us again, but the slander of title, because Mach 2 and Chris Green have lost money from, they've got houses partially finished and finished sitting empty that they can't do anything with. That'll be for trial later.
How large is the tract that you claim is benefited by this crossing?
The total acreage, is my recollection, is 99 acres, some of which has been sold, and I may be including another small tract that's not in this. It's either 99 or something slightly.
Did the tract include property on both sides
Yes, sir.
of the railroad?
Yes, sir.
That went to Highway 19, or does it border up directly onto 19?
The property had a long border with, and the map that's in here shows
They're
it,
hard to
I
read
think.
or reduced.
Yeah, it's real hard to read. But the old line went across Highway 19 is on the other side, because my client actually lived on the other side. Mr. Bruce Green, not Mr. Chris Green. So
I guess my question is, does your client own property on both sides of the rail
Yes, sir.
and property between the rail and 19?
Yes, sir.
Between the rail and 19?
Between the rail, yes, sir.
Okay.
The rail, he owns on both sides of that, and 19's over here, and he owns on, well, his father owned on both sides of that. He doesn't anymore. But he owns between the rail and 19, and on the other side of the rail going up the mountain.
Okay. Thank you, sir.
Thank you. Any other questions?
Thank you very much.
Apologize for going over.
Thank you. Have rebuttal? A little over about 5.5 minutes, and we'll be generous as we were with them. So there's a lot that came out, in terms of questions, and
Yeah.
I don't really know where you want to start.
Well, I know where to start. I think the questioning, I think the arguments, I think the things they said all illustrate why this is not a 12v6 case. They talked about a final action, an action almost 30 years ago. They talked about the railroad taking a voluntary dismissal. They argued that there's not a safety concern because of how slow the train moves. They argued that this is an amusement ride. They brought up the rail in Charlotte. They even alleged that this is not a railroad company, which makes no sense at all. They're regulated just the same as everybody else. Federally regulated, subject to the same regulations. And your Honor asked, some of the, what was behind the 1996 transfer? That's a good question. I think we can answer that question if we get into discovery, if we do that research back into what happened in 1996. but that's not before the court.
When was your predecessor company formed?
The Great Smoky Mountains Railway, Inc. was formed, I want to say, in the late 80s.
1980s?
Yeah, we did a little bit of research, and I'm pretty sure the state bought the property in part to lease it to the railroad as an excursion train. So there was an economic development aspect of the purchase based on our research.
But your company was originally chartered by the Secretary of State under Chapter 55?
Yes.
Okay, and then you have since converted that company to a limited liability company?
Yes, and changed the
Was
name.
it seamless? I mean,
Yes. Yeah.
So you would date back to the original 1990?
Correct.
1980?
Correct. And again, to touch on the allegation that this is not a railroad company, that's the first time it's ever been alleged in this lawsuit, was them standing here right now. And so I'm not in a place to provide the legal support in response to that, but I can assure you they are a railroad company subject to regulations of the state and the feds. They are not an amusement ride. Tweetsee is an amusement ride, perhaps, because they go there and back. But this is an actual passenger train that moves faster than a slow walk. And so it's just like any other passenger train. Amtrak is another passenger train.
Do you have multiple stops?
Yes.
So people can get on and get off multiple times?
The main stops are NOC, Bryson City, obviously, Dillsboro, and then they have where the Polar Express takes place. They have special events there that also stop at. That's in the Whittier area. If you know where Whittier is, it's between Bryson City and Dillsboro. And so there's multiple stops. There are passengers taken to and fro from back and forth.
Multiple stops is one thing. I guess I was inartful with my question. Let me ask you, how many depots are there?
I mean, depots are there?
Depots.
I think it depends how you define a depot. With respect to
Well, is there a depot in Whittier where someone could get on and off the train?
correct.
There is?
Yeah, I don't know. There's not a, well, again, in Whittier, there's a big field.
All right. Well, is there one in Dillsboro?
Correct, yes. There's actually they actually have, Dillsboro, if you've never been there, has a lot of shops and restaurants. And
Does it have a depot?
yeah, there is railroad property there.
What about Bryson City?
Oh, yeah. That's a more classic depot. It's probably how you're thinking about it. Yeah, and NOC has all the stuff you have at a depot. You have restaurants, you have facilities. You have
So
all those things.
you're talking about the NSC. Is that the same as Bryson City, or is that two different?
No, the Nana Hill Outdoor Center is a business located in Almond, which is not really a town, but it's an area of Swain County, and that's one of those popular excursions to go from Bryson City to the Nana Hill Outdoor Center, which is a rafting company that's been around for as long as the railroad's been around. So they have a partnership for dropping them off there. But again, I think, again, we're getting far afield from the 12B6 context. If they want to raise these arguments at the trial court, that's fine. We have rebuttal to all the factual arguments. We can go back and figure out what happened in 1996. We can do all those things, but this is not a 12B6 case. So unless you have other questions, I can go ahead and close.
I just wanted to make sure if your title is void as a claim, I raise this question as whether then doesn't the state have to be, you can't adjudicate the state's title in this action, right?
Right, and exactly right. Yeah, no, that's why the state needs to be here. Like if the states, if they're saying we don't have title, then the state has title, right? And so that's why they're necessary here. Because I think they would say, no, we don't have the title.
And there's two ways, if that's the case, there's two ways to make the state party. You either join them as a party or you appear as a relator for the state, right?
Yeah, or the court, pursuant to Rule 12B7, orders them to, Rule 19, orders them to be joined as party, which is typically what you see when this is brought to the attention of the court. You see a court ordering a certain non-party to be brought in as a party. And by the way, to say this in the brief, that that's necessary party, something this court can consider for the first time. It doesn't need to be considered at the trial court, even though here it was, they alleged as a defense that the state was a necessary party. So there's a concession from them in a lot of respects that the state's a necessary party.
Thank you very much for both your arguments. I just want to mention something. The state, this court, offers a free mediation service that's available to the parties at any time prior to the opinion being issued. So I hope that y'all can come to some agreement at some time. You know, this seems to be something that's been going on a long time. So I just want to make you aware that that service is something this court offers free of charge to the parties. Okay? Yeah, but thank you. The case is submitted. We thank you. This time, Ms. Clerk, will you please adjourn court?
All rise. This session of the North Carolina Court of Appeals is now adjourned.
David, good job. Yeah. Oh, I want to know too. I want to know too. Yeah, it's like, what the hell? Like, yeah, why'd you let this linger? I totally agree. Or it could be-